Good evening, and a very warm welcome to everyone who is joining us both in person and online today. My name is Katya Aristova. I'm a fellow at the Bonneville Institute of Human Rights, where I coordinate research on business, human rights, and environment. It's both a pleasure and indeed an honor for me to moderate today's panel on the impact of business and human rights litigation. We're very fortunate to have with us four remarkable speakers who are coming from very different jurisdictions and offering very different perspectives. But the unique features that all of them have been in some capacity involved directly in the cases targeting corporations and human rights and environmental impact of their operations. So please allow me to introduce speakers briefly for now, but also we'll say a few words later on when the time comes. So next to me is Professor William Dolch, who is the Professor of Comparative Law and Jurisprudence at George Washington University Law School. Next is Ebony Birchall, a lecturer at Macquarie University in Australia. And then the last speaker in the room is Taqbir Huda, who's a human rights lawyer from Bangladesh, but at the moment is based in the US. And joining us online today, I believe from France, is Dr. Anaïs Tobalagba, who is a researcher and human rights lawyer and civil society organization RAID, which stands for Rights and Accountability in Development. Before we begin, please allow me to provide some context for today's event. Over the past year, I have been working as one of the co-editors of the forthcoming handbook on business and human rights litigation, which will be published sometime next year by Cambridge University Press. My co-editors are Hassan Ahmad from Osgood Hall Law School and Rachel Chambers from the University of Connecticut. And together we have collaborated with a distinguished group of scholars and practitioners from all over the world, many of whom are in the audience today, together with my wonderful co-editors. So over the next few days, this group of scholars will be discussing the first draft of the handbook chapters in a closed roundtable. But given the wealth of expertise we have in this building for the next few days, my colleagues at the Bonneville Institute and I thought that it would be a missed opportunity if we don't share some of the knowledge with the public, and this is how this event was born. So I'd like to extend sincere thanks to everyone who traveled to Oxford in person for this occasion. Thank you very much. And a special thanks, of course, as usual, is to the Institute's team who have been working hard in organizing this event and the roundtable. We are also grateful for the financial support provided by several organizations, including Woodsford, Oxford Faculty of Law, the Litigation Trust, University of Connecticut, and of course the Bonneville Institute. The event is being recorded and the video will be uploaded on our YouTube channel, but not the Q&A session to encourage the open discussion. So without any further ado, we are proceeding now to the conversation, and our first speaker will be Bill Dodge, which is not surprising because Bill's expertise includes human rights litigation and the Alien Tort Statute, and in a way ATS litigation involving corporations is considered to be the first wave of business and human rights litigation, which attracted scholars' attention. Bill, during the time of the State Department, Bill worked on several high-profile cases contributed through amicus briefs. And so my question to you, Bill, ATS itself as business legislation has been highly controversial, but based on the years of experience and everything we know to date, how do you assess the so phenomenon of using US courts as a forum for litigating overseas abuses?
Thank you. And I knew what the question was in advance. Right? And I have notes too. I just have them on my phone. So I'm not checking my email when I'm looking down. So it's really a pleasure to be with you to kick off this roundtable. And I want to thank Katya and Rachel and Hassan for inviting me to participate. So as Katya mentioned, business and human rights litigation really began in the United States, and it began in the 1990s under the Alien Tort Statute, or ATS. The ATS is a clause in the first Judiciary Act that set up the federal courts in the United States in 1789. And it simply says the district courts shall have original jurisdiction of any civil action by an alien for a tort only, committed in violation of the law of nations or a treaty of the United States. And you can see the Act's antiquity in its reference to the law of nations, which today we would just say international law. The first human rights cases under the ATS were not corporate cases. They were brought against individuals. The best known of these is Tobalagba versus Peña-Irala, which held in 1980. that the Alien Tort Statute gave jurisdiction to federal courts over, in that case, a claim of torture in Paraguay. The U.S. Supreme Court endorsed this line of cases in Sosa versus Alvarez Chain in 2004 by recognizing an implied cause of action under the ATS for well-established human rights norms. The first significant corporate case was Doe versus Unicap, which was brought in the mid-1990s. In this case, villagers in Myanmar sued a U.S. oil company for aiding and abetting acts of forced labor, murder, rape, and torture by the Burmese military in connection with the building of a pipeline. Now, it would have been possible to bring these claims in U.S. court without the Alien Tort Statute. Federal courts would have subject matter jurisdiction based on the diversity of citizenship of the parties, and many states recognize secondary liability for torts like this in their tort law. I don't know specifically about Myanmar law, but in many countries' law, this kind of suit would be possible. But bringing suit under the ATS had a symbolic value, because the plaintiffs had to show not just that what happened was a violation of domestic tort law, they had to show that it was a violation of international law. And that international condemnation is what lay behind the popularity of using the ATS for business rights. So the advent of corporate cases under the ATS really changed ATS litigation. First, corporations tend to have very good and very well-paid lawyers. In the initial cases against individuals, often the individuals were not represented. And sometimes they didn't even show up to defend against the complaint. It's harder to win cases when the other side shows up and when they make strong arguments. Second, corporate cases made questions of secondary liability critical. Corporations often give support to governments that commit human rights violations instead of committing human rights violations themselves. Sometimes they do that too. But in many cases, we're talking about aiding and abetting, and the prominence of this issue led to disputes in the United States about whether those claims should be covered by federal law or international law, and what the standard for mens rea is for aiding and abetting. Is it a standard of purpose, that you have to have wanted to facilitate the violation, or is knowledge enough? And U.S. courts are still split on that question. And third, a disagreement developed among federal courts about whether corporate liability for human rights violations was well established enough to be actionable under SOSA. And this division among the lower courts led the Supreme Court to grant review in 3 more cases after SOSA. Each time, the court failed to resolve this issue, but each time it took the chance to narrow the ATS cause of action. It's unfortunate, I think, that the first 2 corporate cases that reached the U.S. Supreme Court were cases against foreign corporations. It just seems, well, they were Kyogo versus Royal Dutch Petroleum and Jessner versus Aerobank. It just seems less reasonable for U.S. courts to be sitting in judgment of foreign corporations acting outside the United States than it does for them to be sitting in judgment of U.S. corporations acting outside of the United States. Additionally, it got foreign governments involved. In Kyogo, the United Kingdom and the Netherlands filed an amicus brief in support of Royal Dutch Petroleum, which is an Anglo-Dutch, or was at least an Anglo-Dutch company, arguing that it was actually the United States that was violating international law by assuming jurisdiction over this kind of case. Now, ultimately, in Jessner, the Supreme Court held that the ATS cause of action did not apply to foreign corporations, but by then, some of the damage was done. Many of the justices on the Supreme Court had developed negative views of the ATS, and I think that this story might have gone differently if the first corporate cases to reach the U.S. Supreme Court had involved U.S. corporate defendants, like the Unical case or the West case, which came later. So this is a long way of working around to your question. I believe that it is appropriate for U.S. courts to hear cases involving human rights violations abroad. Often the courts of the place where the violations occurred are not available. Can particularly be the case if the government that committed the human rights violations is still in power. Nor is it illegitimate to apply international law to the defendants in these cases. International law is universally binding. It is not an imposition of U.S. law and U.S. moral standards to be applying international law to people who violate human rights. International law, human rights law applies to corporations just as it applies to individuals. In a brief that Katya referred to, when I took a year off and worked at the State Department during the Obama administration, we worked on a brief in the Kyoto case because the first round of the Kyoto case involved this question of corporate liability. And the US government in that case took the position that norms such as torture, genocide, and war crimes prohibit those acts irrespective of who's committing them. So it doesn't matter whether you're a natural person or a juridical person. What is prohibited by the customary international law against torture, for example, is torture. And it doesn't distinguish who the torture is. And the first Trump administration reversed that position. That's the case. But I still believe that as part of international law, it's absolutely correct. And even if the United States were to apply its own law in these cases, these are cases that involve universal jurisdiction, where every country, even if it doesn't have a connection to the case, has jurisdiction to prescribe rules, has jurisdiction to make law that prohibits liability for these violations. I do think, as a general matter, it's probably best for the courts of the home country of the corporation to take primary responsibility for human rights violations by its nationals when those courts are available. But that's not an exclusive jurisdiction, nor should it. I do think that business and human rights litigation in the United States has encouraged development in other countries. Developments that we're going to be hearing much more about over the next 2 days. And I think that is a legacy. Even though the future for human rights litigation under the tort statute looks rather dim at the moment, I think that's a legacy that the people who first brought these cases can be proud of. And I'll stop there.
Thank you very much.
Yeah, I don't think I'm over 10.
No, that'd be fine. I think you've covered a few quite important and big questions about extractive jurisdictions, including not just in the legal realm, but also policy realm as well. I think what's becoming clear over the years is that this is a decided question about which was the jurisdictions, but also we've been hearing so much about litigation in the home jurisdictions, and then about the jurisdiction of local countries. Litigation in the local jurisdictions is sometimes overlooked. So giving voice to the local lawyers who actually have been involved in litigation in some of the global south jurisdictions. We are now turning to Taqbir, who until recently, most recently, served as the South Asia Regional Researcher at Amnesty International. I actually want to speak about your research and about your work in Bangladesh, where you led advocacy and campaign and research for several human rights organizations and was involved in public interest litigation in the Supreme Court, including in the connection with the Rana Plaza collapse many years ago. So the question to you is, to what extent do you think litigation has been effective in holding businesses accountable for the Rana Plaza collapse, but also whether anything has changed in the area?
Right, thank you, Katya, and thank you so much to all the organizers for having us here. I want all of us to sort of go back in time. I want to transport you back to April 24, 2013. On the morning of April 24, 2013 in Bangladesh, an 8-story building had visible cracks, which is why the large chunk of commercial establishments which were located inside this building had vacated, except for 5 garment factories which were operating inside that building, and because they had shipment deadlines to be made. As it turns out, Walmart, Mango, H&M, Primark are not too forgiving when it comes to deadlines. When they set a deadline, it needs to be met. So the producers were telling the workers, we don't care if you can see cracks. We don't care if everyone else has decided it's far too unsafe to go inside. You must go in and you must produce clothes or lose a month's pay. Now, for workers who live what we say, quote unquote, hand to mouth, they could not really afford to lose a month's pay. So they went in, but they never came out because lo and behold, within a couple of hours, the entire building collapsed, crushing everything in its path and killing every person almost. So we know the official death toll is 1,134. And the injuries are thousands more, but why I say that the official death toll is a conservative estimate is because the authoritarian prime minister who was then in charge, who has recently fled, is now coming up with it is now being told that she deliberately suppressed the death toll because she wanted to contain the reputational harm that was resulting from the increasing death toll. Anyway, 1,134 workers, still so many lives lost in a purely preventable collapse. So what happened? Like, what is accountability in such a situation? Now, because the volume focuses on litigation, on a purely literalist construction, I was like, my person was like trying to enlist the number of cases that were filed in Bangladesh. And I was able to identify 20 that were filed in Rana Plaza. Now, what might shock you is the vast majority of these 20 cases were actually criminal cases. 15 of them were criminal cases, seeking imprisonment of the building owner, the 5 garment factory owners, and some individuals who were part of regulatory authorities who were seen to have failed their job. Only one of them was what we could consider a civil tort case. And the remaining 4 were constitutional cases, one of which I was directly involved in. Now, I just want to briefly focus on the 15 criminal cases. All of them remain pending. Only one of them led to the conviction of the building owner in an anti-corruption case, and he received the maximum punishment, which is 3 years. He still remains in prison, but everyone else is out on bail. Criminal cases also include murder charges, which is punishable by the death penalty. But anyway, for all intents and purposes, these cases are in a bit of a limbo. The civil case is most interesting. It was filed by Rubina, who is a widow of one of the workers who were killed. And she appears to have filed this case completely on her own, despite the explosion of interest among human rights groups to assist the victims. So she sued, this would probably be the most obvious case in response to the Rana Plaza collapse, which is a wrongful death claim and negligence, seeking damages. Now, the sad thing is that's all we know about Rubina and her case, because no one has been able to trace her since then. We found out about this case years later, because it was stuck in limbo for 4 years, and then it came up for a hearing, and Rubina never showed up. And then it was dismissed for, the claimant not showing up. So now human rights groups and my colleagues are actively looking for Rubina so we could revive the case. But, who knows why she never came back, probably. You must understand, Rubina was fighting an uphill battle. Because Bangladesh is what I would say is a country that suffers from a shortfall deficit. She would not have any successful case to cite in her paper. Even if she did, she would be looking at 30 years of convincing judges that this is an actionable case, this is something she deserves money for. Because by and large, the history of colonization has meant that punitive responses to rights violations, no matter how egregious they be, is the only form of response that the state knows, is the only form of response most people can aspire to. So from a sociological point of view, it would be incredibly interesting to find out where Rubina, like how she managed to, go against this general trend and the challenges she faced. Now, coming to the constitutional case. Now, these were four largely similar fact patterns, so I'll just combine them and speak about the one that I was directly involved in. This was filed by two human rights organizations who have been the first to file these public interest litigation cases whenever such mass torts have happened. So Rana Plaza was certainly not the first time quote unquote tragedy struck the garment sector in Bangladesh. It was the most visible rupture in what was a very thin veil through which these disastrous instances of corporate negligence was being carefully hidden. Just 3 months before Rana Plaza, about 200 workers died producing again clothes for brands like Walmart. And this time they were burned to death because the building caught fire and they could not escape because their employers had locked the doors shut because they were afraid workers were taking too many breaks. So Rana Plaza, no one can claim that Rana Plaza was unforeseeable or that it was a tragedy. It was a completely foreseeable act of corporate negligence that was the result of corporate impunity. Now, this public interest litigation case was filed within the reality of Bangladesh, where tort cases are incredibly difficult to argue. And this is like an alternative remedial pathway that human rights lawyers have carved out over the years. You can seek compensation in public law without any of the procedural hurdles of private or tort law. So essentially what was being sought is like a class action-like suit on behalf of the victims pending compensation and a range of other reparation and remedies. But outside the world of litigation, something more significant and decisive was happening, and that is the Rana Plaza arrangement. Now, the Rana Plaza arrangement is a quote-unquote practical agreement between Western brands, a Western NGO, a host of Bangladeshi corporations, and Bangladeshi state. They decided very early on that Rana Plaza could not be the subject of any litigation, that the settlement to this quote-unquote tragedy had to be outside the courts, and it had to be charitable, based on notions of humanitarian goodwill rather than legal responsibility. So what this Rana Plaza arrangement does then is it diffuses the outrage that was rendered, and which the kind of outrage that is typically needed for some of those public interest litigation cases to continue. So within about a year and a half, it managed to amass about 34 million from massive brands and paid them off in line with what they called were ILO standards or ILO Convention 121. Now, this was a grand story of success because you see, in Bangladesh's Labor Act, all the workers would have been entitled to, or the victims of the deceased workers would have been entitled to, was 100,000 taka, which is roughly 1,000 pounds back then. So compared to that, this seems like a massive act of brand benevolence that, brands could have just complied with what was prescribed by local law, but they didn't. I mean, from my rough estimation, according to the Labor Act, the liability would have been about 950,000 USD just for the deceased workers. If you add on the injured workers, it could be probably maybe maximum 2 million. So compared to that, they paid so much more, right? It was 34 million. So that is really the story. But the public interest litigation case was sort of to question these presumptions, like why must compensation be based on that arbitrary liability regime that was introduced under the Labor Act? Why can it not be based on rights respecting or liability enhancing regimes like torts? And that is essentially the argument that we were making. But you see, because the money had already been dispersed, because of all the CSR money that went into promoting this as a grand act of, success. It, by the way, was replicated in other contexts, like the Ali Enterprises fire in Pakistan and the fast reintroduction fire in Bangladesh. So by and large, you ask anyone in the ILO world, you ask anyone even in most supply chain diligence world, they'll say Rana Plaza arrangement was a very huge success. And that's also the challenge we had with the court when the thing came up in hearing in 2021, where the court was like, didn't they already receive money from this massive fund, which was like so much more than any deceased worker could expect under the Labor Act? So what more do you want? What more should we order these corporations to pay? So that's when we kept on arguing that, hold on, the liability was based on notions of charitable will, it was not based on legal responsibility. Never was it referred to as compensation, it was referred to as financial assistance. It excluded any damages or compensation for pain and suffering. It only recognized a partial loss of earnings, as I will point out. So we were making an arithmetical argument as well as a legal one, that there is so much more to be recovered. And that is currently where that case is. That is, whether or not the court will be convinced by this argument remains unsettled. But I think it brings up fundamental questions, not only in the world of corporate accountability, but in the human rights movement more generally. Can administrative compensations or ex gratia payments really neutralize the need for fault-based liability through litigation? Or does human rights violation, the vindication of human rights violations, require judicial enforcement? And this is a dilemma that I think even the Human Rights Committee has not sufficiently grappled with, because that's another issue that I'm currently looking at. And Rana Plaza really is the catalyst where this dilemma thrives. And I urge us to think about it, because the brands and their supporters and the government of Bangladesh will tell you that litigation has no role here. Rana Plaza arrangement was a huge success. They got what they deserved. In fact, they got so much more than they were entitled to under the Labor Act. So, that's it. But as a human rights defender, I'm slightly uncomfortable in closing the book on Rana Plaza when till this day, not one penny has been paid by way of compensation for wrongful injury. And I would pose that dilemma to you, because that is the research question that I'm working on for the better part of this year. And really, I think Rana Plaza has to be at the forefront of this dilemma, that, can you essentially purchase immunity through this small chunk of money? And I say small because, 34 million was higher than the arbitrary standard applicable under labor law, but it was certainly just a fraction of what a tort or a rights-based litigation case would have rendered. And I want to end by quoting one of the survivors of Rana Plaza, who received money from this Rana Plaza arrangement. And she says in 2017 to a journalist that the compensation I got after the crash was mostly spent on my treatment. Now I can't work like I used to. I have no regular income, and there are days I wish I had not survived Rana Plaza. So those are the words of one of the beneficiaries of what has been touted as a grand success in the world. And with that approach, so that we can reflect if this is really accountability or if this is not. Thank you.
Thank you very much, Taqbir. It gives a lot of food for thought for us. Can I ask people a question about criminal cases that are still ongoing? Do you think they have a better prospect of success or any alternative for providing justice?
So these criminal cases have so many witnesses that the trial will probably continue forever. Sohail Rana, who's the building owner, has been now in prison for 11 years. So he served essentially like an 11-year prison sentence, and he'll probably die in prison. But the question is, what about the liability of the garment owners? They were able to secure bail. So I genuinely think that we will just continue seeing these cases progress at snail's pace, and the ostensible ground on which they will be delayed is that, oh, we have so many witnesses to interview and the witnesses are launching.
Thank you. Sure, we'll continue this discussion later on. But now I'll encourage to move to a completely different case study and to our online speaker, Anaïs, who have conducted extensive desk and field research on the human rights and environmental impacts of extractive industries in Africa, and particularly in the Congo, which is the focus of our conversation today. And my question for Anaïs is, how, in your view, you think effective litigation has been in addressing corporate human rights abuses in the region, and whether significant actions primarily have taken place within Congo's jurisdiction or outside?
Can you hear me? Yes?
We can, yeah.
Yeah, okay, fantastic. So thank you for the invitation, and thank you for the question, Katya. I just want to put things a little bit into the context of the Democratic Republic of Congo, which is the area where I work the most at the moment. A lot of you will know that the Democratic Republic of Congo is a country which is extremely rich in natural resources, and really the mineral exploration and exploitation has been a complete part of the country's colonial and post-colonial history, and it's always been linked to human rights abuses. And in the early 2000s to mid-2000s, we witnessed a mining boom in the region, which was linked to the energy transition and the increased demand for copper and cobalt, because the DRC is actually one of the regions in the world where you find the most of these minerals. 70% of the world's global supply of cobalt comes from the DRC, and the country is also the third world producer of copper. So with this mining boom, we've seen an influx of mining companies operating in the area, and with it, an influx of human rights and environmental abuses. At the same time, a lot of you will know as well that the Democratic Republic of Congo is a highly corrupt country. It ranks 162nd out of 180 countries that have been evaluated by Transparency International on their corruption perception index. So all this really has created fertile ground, I want to say, for corporate misconduct and for weak enforcement of domestic and international human rights standards. And I want to flag the fact that in the DRC, there's actually quite a strong legal framework in relation to protecting human rights and the environment. So in that context, civil society organizations based in the DRC and Congolese lawyers have challenged the practices of companies for a very long time. Traditionally, this has happened via advocacy, but increasingly we're seeing cases being brought by the civil society organizations and by these Congolese lawyers before courts. And this is it's in this growing context of litigation in the DRC or in relation to mineral extraction in the DRC that we're starting to understand a bit more of the value of human rights strategic litigation in addressing the human rights and environmental abuses that are related to mining in the DRC, and more largely to the energy transition. A lot of the high-profile cases that we know about that address these issues have been filed in the home states of the multinational companies. And I'm just going to mention 3 cases just to give you a little bit of a understanding of what we're at the moment in terms of strategic litigation in relation to the energy transition and the DRC. One of the best known case and one of the older cases is the one against Anvil Mining, both in Canada and in the DRC, for the company was allegedly supporting a military operation that led to severe human rights abuses. So we're talking about summary execution, tortures, arbitrary detention, rape, etc. And really, I mean, although the case was quite long-lasting with a lot of different stakeholders, it yielded quite limited results because both cases failed at procedural level. Then a claim was filed with the African Commission on Human and People's Rights, which in 2017 ordered the Congolese state to provide remedy to the claimants, and it was quite substantive remedy as well, and to launch a new criminal investigation into the case. But since 2017, nothing has happened. More recently, we are seeing quite a lot of interest in relation to litigation related to extractive industries in the DRC. For example, in 2019, two French NGOs, so Sherpa and Friends of the Earth France, filed a case under the French duty of vigilance law against the oil company Perenco for environmental damage in the coastal region of the DRC. There were quite a bit of procedural hurdles in that case, but it's now being heard by the Paris court, and we don't have any outcome yet, but it will be really interesting to see what the approach of the court is in actually developing judicial framework in France as well, to see what decision is made on that particular case. And one of the big cases as well that we know of was filed in the US, and it's actually a supply chain case against 5 major US tech companies that were accused of aiding and abetting in the death and injury of children working in artisanal cobalt mines in the DRC. The case was dismissed, unfortunately, quite recently, if I remember well, it was last year. So, overall, when we think about it from a purely, litigation point of view, the results so far are quite limited. But at the same time, and I think that's where it has been a key and potentially strategic outcome of this litigation in home states, is that it really has raised awareness on the environmental and human rights abuses that are linked to extractive industries in the DRC and that are linked to the energy transition. And we're seeing that a lot in our conversation with policymakers, with regulators, with supply chain companies. There is more and more pressure for more transparency in copper and cobalt supply chains, although I will admit there is still a lot of work to be done. But we're seeing as well, more interest from regulators as well. So I think, it hasn't been a complete failure if I can say. And at the same time, as I mentioned a bit before, Congolese courts are increasingly hearing human rights and environmental cases against the subsidiaries of the multinational mining companies and their Congolese subcontractors. And, this is, picking up at the moment because of that mining boom that I mentioned, because of the energy transition. But really, we've traced some of the earlier cases that we can label business and human rights cases in the DRC back in the 1990s. And in practice, it's quite difficult to understand the scope of business and human rights litigation in the DRC, just because it's very difficult to access court documents. The judiciary and the judicial system in the DRC is not digitalized. So really, one of the only ways to have access to court documents and to case files is to go to the registry of all the different cities, sit down, go through hundreds of pages of court cases, and take photos or photocopies of the ones that are relevant. And this is a process that RAID has started doing. At the moment, we've identified about 15 cases, but we're continuing that work. And it's really giving us a clearer, although relatively small, picture of the landscape of business and human rights litigation in the DRC. At the same time, we're seeing more and more, as I said, Congolese civil society organizations bringing cases, in particular in relation to workers' rights. So in relation to the workers and the labor rights of the workers who work in these big industrial mines. And I don't know if surprisingly, but we have seen quite a few successes. It's quite, I mean, it is definitely too early to say if DRC-based litigation is effective in influencing corporate practices at a systemic level, but we're witnessing some individual companies changing some of their practices. It's small, but it's still there. And that happens in particular when civil society organizations in the global north, like RAID, for example, amplify these litigation efforts and advocate with consumer-facing companies. So the companies that use the copper and the cobalt from the DRC, most of them nowadays are tech companies and very largely electric vehicle manufacturers. So still early stages, still, you know, a lot to understand about the impact of DRC-based BHR litigation, but, you know, small corporate changes, and also we're seeing that it's slightly influencing the practices of courts, because the Congolese courts are now gaining more knowledge and more expertise in BHR litigation. And it's also been really critical in mobilizing rights holders in the DRC and internationally as well to ask for corporate accountability. So there would be a lot more to say. I think I'm at my 10 minutes, so I will stop here, but I'm very happy to answer more questions later on. I can't hear you.
Yeah, can you hear me now?
Yeah, I can.
A very quick follow-up question, maybe 1 minute or so. So you mentioned that there are cases brought within Congo by Congolese organizations, but also outside by civil society organizations, Western, I assume. Do you see any collaborations effective between these civil society sectors in different jurisdictions, Western and Congolese ones?
Yes, absolutely. And it's something that we're seeing more and more, and that we think is critical in bringing more awareness about the worldly potential of business and human rights litigation. We've had, you know, some failures in some jurisdictions. We've had some failures and some successes in the DRC. So we're trying to understand more broadly what kind of cooperation between Global North and Global South organizations can bring these cases to the forefront of the business and human rights debate as well. And, you know, develop new strategies about understanding how we can provide better remedy for the victims of business and human rights abuses in host states, which I believe, you know, is one of the themes that is still lacking a lot of attention in the whole business and human rights discussion.
Thank you very much, Anaïs. I'm sure there will be more questions from the audience, but mindful about the time. Our last speaker for the day is Ebony Birchall from Australia, who has extensive litigation experience in Australia, including in cases such as the Manus Island class action. But my question to you is more about your academic work. you co-authored a report together with Professor Surya Diva and Justin Nolan, titled "The Impact of Strategic Human Rights Litigation on Corporate Behavior," that was commissioned by Freedom Fund and was published in November 2023, and where you suggest a framework to assess the impact of the cases we've been discussing today. So the question is kindly asking you to summarize in 10 minutes the key findings, but also, did you find anything particularly surprising in the findings or impactful that you want to share with us?
Yeah, thank you. Thanks so much to the organisers for having me here. And I just wanted to quickly acknowledge Professor Diva and Professor Nolan, who wrote this report with me, and also the Freedom Fund, who provided a grant for us to do this research. Without that, we wouldn't have been able to do it. And this report that I'm talking about, it's freely available online on the Freedom Fund's website. So if I say anything that you're interested in, go and have a look at the report. There's lots of really interesting case studies in the report. I think it's quite a good read. So our report. So we looked at strategic litigation in the business and human rights space. And the way that we define strategic litigation is litigation that seeks to bring about systemic change and to encourage corporations to operate with greater respect for people and the environment. And this type of litigation, as we've heard tonight, has been a key tool that's been used in this space for several decades. And I guess our question was, how effective is using strategic litigation as a tool to cause change? Because, sometimes you see the sort of big results, the big compensation payments, and you think, oh, that's, really exciting and it's a really effective way to cause change. But our question is, well, is this type of litigation actually causing change? Is it actually causing corporations to change their behaviour? So there wasn't much research on this front when we started, and I guess the gap in the existing literature is unsurprising because there's quite a lot of challenges in trying to research that question and to make a sort of holistic assessment of strategic litigation. As we've heard tonight, lots of different cases out there are very different. They're in different jurisdictions. Some cases are successful in some ways, some cases have absolutely no success at all, some cases don't even get off the ground kind of thing. So it's difficult to make a holistic sort of assessment of this. There's also difficulties in terms of there are different views from different people involved in litigation. So sometimes rights holders involved in the litigation will have a different perspective on what is success and what they want from the litigation compared to civil society organisations involved or other people involved. There's also difficulties in making sort of causal connections. So you talk about a piece of litigation and you're trying to assess whether that piece of litigation has actually gone on to cause, policy change or legal change or even corporate practice change. Often that causal connection is really difficult to identify. And in particular, when we're talking about corporations and changes in corporate practice, corporations are very reluctant to sort of admit or disclose whether or not litigation has actually impacted their practices for a few different reasons. So that were kind of the difficulties we encountered when we were working out how do we actually research this question. So in terms of our methodology, what we did do is we reviewed a database of business and human rights cases. We interviewed a range of stakeholders around the world, so diverse stakeholders and litigators, civil society, actors involved in litigation, business advisors, so lawyers advising businesses, and we tried to get people from diverse regions and tried to be as diverse as we could. We also hosted a workshop alongside one of the UN Business and Human Rights forums just to get another room full of people together to talk about this question. And when we were looking at litigation, we weren't just interested in the actual outcome from the case, so whether or not the court said, the business is liable and pay this amount of money. We weren't so much interested in just that sort of specific direct outcome. We were more interested in all of the indirect and sort of diverse impacts that piece of litigation can have more broadly on society. And so to do that, we sort of used a concept of a corporate ecosystem. So what we mean by that is the network of factors or stakeholders that interact with corporations and that can in turn influence corporate behaviour. So just to give one example of one stakeholder that interacts with corporations is consumers, for example. So if a piece of litigation raised awareness to consumers about bad practices, then the consumers, might change their idea of a particular business, and then make different decisions about how they use their money, and then that can go on to impact the corporation, who then might want to change their practices. So that's kind of the idea of the corporate ecosystem, and how litigation can impact the corporate ecosystem, which then goes on to impact corporate behaviour. So yeah, we're looking at those more diverse impacts of litigation. And what we found was that litigation definitely has had positive impacts on corporate behaviour. So in the report it goes through all of these different positive impacts, but things like raising public awareness to human rights violations. So often a piece of litigation is filed, it catches the attention of the media then report on it, and in that way public awareness is increased. So that's a positive impact that litigation has. Litigation can also influence changes in corporate policies and practices. One thing we heard from business advisors and other interviewees was that commencing litigation will often get the attention of corporate executives in the way that other advocacy efforts wouldn't. So litigation can then have a change or an influence on corporate policies. Litigation can address power imbalances by forcing corporations to take complaints of rights holders more seriously. Often we heard that corporations can sort of ignore rights holders and ignore sort of complaints until litigation is commenced, and then corporations can't ignore it any longer. Litigation can create access to remedies. So litigation has been successful in remedying harm for rights holders, successful obviously to varying degrees in different cases. Litigation has opened up new pathways for corporate accountability. So just to take one example, the Nepson case in Canada, clarified the applicability of customary international law to corporations in Canada, and that's one example of litigation actually creating new pathways of corporate accountability. And so these are sort of the rarer cases that are sort of more of the big ticket impact items. And litigation can also trigger changes in law. So, a piece of litigation can highlight a gap in existing law and regulation, and the governments can respond to that. So these are some of the positive impacts that we identified that litigation can actually cause. But on the other hand, litigation has also resulted in negative impacts. So it's not all positive. There are definitely negative impacts and risks involved in litigation. And so they also need to be taken into account. So some of these negative impacts are things like SLAPs, so strategic litigation against public participation, is something that's increasing, sadly. And we identify cases where a piece of litigation was commenced, and as the corporation has responded by issuing a SLAP piece of litigation. Litigation can increase divisions within communities. Often business and human rights litigation is brought on behalf of the community rather than just one individual. And we have some examples where corporations would target key community leaders and try and buy off key community leaders or create divisions in communities, and there are other examples like that. So that's a potential negative impact. There's also negative impacts from positive judgments that can occur. So, for example, the Vedanta judgment is positive in that it's helping to develop a direct duty of care principle for parent companies, but then there's potentially negative impacts to that, in that the Vedanta judgment, some people have told us as part of our interviews, it has reduced the disclosure of corporate information by some companies because of the risk of litigation. So there are some sort of flip sides there, even in positive judgments. And then also litigation can cause the negative impact of the adoption of regressive laws or policies. So if a piece of litigation is successful, sometimes governments respond by basically like introducing regressive laws to overturn the precedent that's been created. So there are examples of that as well. So both positive and negative impacts of litigation. And so overall, when we're sort of doing a holistic assessment, we need to take into account both the positive and negative impacts. And overall, the systemic impact of litigation on corporate behaviour has been slow and patchy. Is kind of our final conclusion. Litigation has definitely worked in some cases successfully, but then not in others. But even within the one case, like if you just look at, trying to assess one case, there could be positive outcomes as well as negative outcomes within the one case. And as I mentioned before, different stakeholders involved in the one case might actually have varying perspectives on whether or not that one case was successful or not. So it's very difficult to make a, holistic, broad brush assessment of strategic litigation. It's quite complex and numerous factors involved. So we provided 6 key strategies or variables to look at when we're trying to maximise the impact of litigation in order to create change and change corporate behaviour. So the first variable is case selection. So case selection is the most important variable. So you need to take into account variables like the profile of the company. If the profile of the company is public facing, then they're going to be more responsive to public pressures, so reputational pressures, the seriousness of the allegations. If we're talking about serious human rights violations, that's again going to have more reputational pressure involved than if we're talking about a negligence case. You have to look at the suitability of the forum. Some jurisdictions we heard from interviewing, some jurisdictions simply just not worth for any litigation to begin with because the forum is just not suitable. And then also assessing how credible the evidence is that you've got involved in the case, how likely it is to succeed. So there's some of the variables in terms of case selection. Number 2, in terms of strategies, you have to evaluate and manage the risks of litigation, particularly those negative risks we talked about in terms of slaps or even, risk of violence and, the risk of regressive precedent. The third strategy is to make sure you're collaborating with reliable local partners. This type of litigation, because it's often transnational, usually involves several organisations and people involved. So making sure that we're collaborating with reliable local partners. We had some examples where litigations failed because the people involved weren't reliable. Number 4 strategy is managing expectations and competing goals. So again, because this type of litigation often involves a range of organisations, often each organisation will have their own goal, rights holders involved will have their own goals and perspectives. So it's really important that you're managing those different needs and goals and perspectives. And it's also really important that the rights holders should remain central as part of the litigation, because you can't sacrifice the needs and the rights of the rights holders in order to create some broader social change. So yeah, really important that the rights holders remain central to the litigation. Number 5 strategy is employing complementary redress mechanisms. So firstly, you need to think about, is litigation actually the best option for the circumstances? There might be other mechanisms that are more suitable. And it's really important to think about other mechanisms that you can leverage as part of the broader campaign. So yeah, litigation should really be seen as one tool in the broader toolbox. And we found that campaigns are most successful when there are multiple mechanisms being used. And the last strategy is just making sure that you've secured sustainable funding, because the nature of litigation is unpredictable and you need to be thinking long term with these type of cases. So that is the summary of the report. In terms of your last question, which was, is there any particularly sort of impactful binding? I think I would go back to the role of complementary strategies. I think something that became clear to me while I was doing this report, there's a lot of synergy between litigation and the broader advocacy campaign that's going on. So litigation often can't make systemic changes on its own. And litigation often relies on other advocacy campaigns to even begin. So often, you need other advocacy to unearth evidence before you can then commence litigation. So there's like a synergy there that needs to be respected that, that I think is really important.
I think you can certainly see this in the climate change litigation, this toolbox of how litigation is integrated with other strategies.
And it also
with what Anaïs was talking
certainly. Thank you very much. I do have questions, but I don't want to overuse my role as moderator, so I'll open the floor